I want you to just imagine a scenario for a second. It's a bit of a nightmare, really.
Okay.
You're in danger, real physical danger. So you do exactly what you're taught to do. You go to the police, you file a formal request for protection, they process it, they even hand you a receipt.
Right. It's got the official stamp, the signature, the whole deal.
Exactly. You walk out holding that piece of paper thinking, okay, the system knows I'm on the record.
That's the social contract, isn't it?
Yeah.
You report a threat, the system creates a record, and things start moving.
But then a few weeks later, you're in the high court because, well, that protection never showed up. And the state's own lawyer stands up, looks the judge right in the eye and says, Your Honor, this person never came to us.
We have no idea who this is.
We have absolutely no record of him.
That is pure gaslighting. It's something out of Kafka.
Yeah.
You're holding the proof, but the official story in the room is just erasing your reality.
And here's the kicker. The judge believes the lawyer. The judge looks at you and says, well, since you didn't follow the rules and ask the police first, I can't help you. Go back and do that.
But you already did it. It's a perfect, inescapable bureaucratic loop.
And this, unfortunately, is not a hypothetical. It is the absolute core conflict in a writ petition that's been filed directly in the Supreme Court of India.
The case is Push Sharma versus State of Punjab.
And that's the case we're unpacking today. We've got the petition itself, filed December 10th, 2025, a whole stack of annexures, court orders. But this is so much more than a story about paperwork.
Oh, much bigger. We're calling it the conflict of record and representation. It really makes you ask, what happens when the physical file, the actual truth, says one thing?
And the official lawyer in court says the complete opposite. Which one wins?
And the stakes couldn't be higher. This isn't just some clerical mix-up. This petition is filed under Article 32 of the Constitution.
The heart and soul of the Constitution.
Exactly. It's the right that lets you go straight to the Supreme Court when a fundamental right is violated. And here, we're talking about Article 21, the right to life.
So the mission for this deep dive is to trace that timeline, to see how fraud or misrepresentation, as the petition alleges, can just completely poison a judicial proceeding. So let's start with the petitioner. Who is Pushparam?
According to the synopsis in the petition, he's an investigative journalist and also a law student. But he's not, covering local politics. He's in a much more dangerous arena.
The documents say he's a witness and an informant in the Supreme Court-monitored Faridkot sacrilege case from 2015. For anyone who might not be familiar with that, can you just explain the gravity of it?
It's hard to overstate. The 2015 sacrilege incidents, where religious texts were desecrated, led to huge civil unrest, police firings, deaths. It's an incredibly sensitive and political issue in Punjab.
So being a witness in that case puts a target on your back.
Immediately. But the threat level seems to have jumped up quite a bit in the last few years. The sources say that between 2018 and 2023, Sharma was in London.
Right, and what was he doing there?
He was working. The petition says he obtained foreign investigative material. And we're talking about financial links. Specifically, who was funding these sacrilege incidents?
And a big name comes up.
A very big name. Nirav Deepak Modi.
The fugitive diamond merchant. So this connects a local religious issue to a huge international financial scandal.
Precisely. And this isn't just Sharma's claim. The documents mention this material was put in a sealed cover before the Delhi High Court in 2022.
Okay, let's pause on that sealed cover. We hear that term a lot. What does it actually mean here?
It means the information is so sensitive that only the judges get to see it. It's not read out in open court. The fact that his findings were given that treatment suggests he's sitting on something pretty explosive.
So he comes back to India, he's assisting the investigation, and then on April 6, 2025, he files a complaint naming a specific mastermind. He's naming names, supported by hidden camera footage.
You can just feel the temperature rising as you read the timeline. When you start naming powerful people, connecting them to these kinds of crimes, the pushback, well, it tends to become physical.
Which brings us to June 1st, 2025. The petition is very clear. The petitioner was physically attacked and hospitalized.
And that's the catalyst.
Yeah.
The abstract threat is now a physical reality. So, of course, he goes to seek protection.
And this is where we get to the smoking gun of this entire deep dive, this one document that makes everything so contradictory. It's Annexure P6.
Ah, yes, Annexure P6. It looks like a boring little administrative slip, but in this case, it's the pivot point. It's everything.
So pin a picture for us. It's a diary entry, number 40045 SSP, dated June 18th, 2025. It comes from the Office of the Senior Superintendent of Police. What does it say?
It says the system worked at first. It confirms, in black and white, that his threat representation was received. It's got a handwritten note forwarding it to the DSP in Zirakpur for necessary action.
And it says it was taken up for examination.
Yes. So to be crystal clear, on June 18th, the police officially acknowledged, "We have your complaint, we're on it." He has the receipt.
So when he goes to the High Court of Punjab and Haryana after this, it should be a simple conversation. I filed this. Here's the receipt. I need protection. Why didn't it work that way?
It should have. But this is where the story enters, a sort of twilight zone. We have to look at what the state's lawyers said in court between July and September 2025.
Okay, so he files his petition in July. The additional advocate general stands up before the judge. And what's the argument?
I'm reading from the order from July 28. The state counsel argues, and this is key on instructions, that the petitioner has not approached the respondent so far.
Has not approached.
Okay.
Annexure P6. The diary entry, that was June 18th. That's over a month before this hearing. How can they just say that?
Well, on instructions is the phrase lawyers use. It means, I'm not making this up, the police told me to tell you this. The problem is, the court relies on that. There's a presumption that the state is telling the truth.
And the judge just buys it.
Yes. The judge disposes of the petition, basically saying, well, since you haven't asked the police yet, go ask them first. The court orders him to do the one thing he has already done.
But surely he objects. He's standing right there. He could just hold up the receipt.
He tries. But you know the power dynamic in a courtroom.
Yeah.
One guy waving a piece of paper versus the state's formal statement on the record. The court defaults to the state. And this didn't just happen once.
It's a pattern. I'm looking at the orders. July 28, August 27, September 1st, September 8. It's the same story every time. The petitioner is premature.
And he's just sitting there with the diary number in his pocket.
Yeah.
It must have been infuriating. But then the government story starts to unravel internally.
Here's where it gets strange. The governor gets involved.
Yeah, which is very unusual. On September 4, the governor's office orders an inquiry into what it calls an apparent fraud upon the court.
Fraud upon the court. That's strong language.
Very strong. And then the very next day, look at Annexure P7. It's an internal police email from the Bureau of Investigation, the BOI.
And what does it say?
It confirms that Sharma's complaint about the state's misrepresentation was already being processed.
Okay, wait. Let's get this timeline straight because this is the gotcha moment. September 5, the police internally admit, yes, we're processing his complaint about the lies.
Right.
September 8, the state lawyers go back into the high court and say, what?
They repeat the lie. They say he hasn't approached them.
That's a logical impossibility. They knew on the 5th but denied it on the 8th. That doesn't sound like a mistake.
No, it implies a coordinated effort to keep the truth from the judge.
But why? I mean, why go to all this trouble to deny a simple receipt exists?
A synopsis suggests a much darker reason, a chilling effect. After that September 8 hearing, state representatives allegedly warned him.
Warned him how?
They allegedly told him that if he used that sealed police record diary number 445 to prove they were lying, he could face action under the Official Secrets Act.
Whoa. The Official Secrets Act. That's for espionage. They threaten him with treason charges for showing a receipt about his own protection request.
That's the allegation. And it's a brilliant, if terrifying trap. They're basically saying the police file is a state secret. So using it to prove their public statement was false would be a crime. It gagged him.
So he's trapped. If he speaks up, he's a spy. If he stays silent, the court thinks he's a liar.
And the trap snaps shut on October 16. The state brings up the doctrine of res judicata.
Okay, break that down for us. What does that Latin term mean in practice?
It means the matter has been judged. It's a rule to stop people from relitigating the same issue over and over. The state argued, look, the court already dismissed his case in July and August. He can't bring it again.
But those dismissals were based on a lie.
Exactly. But because those orders were on the record, they created a legal barrier. They used the orders they got through the alleged misrepresentation to block any new attempt to get protection. He was forced to withdraw.
So the system completely boxed him in. Which brings us to the present. December 10th, 2025. He goes to the Supreme Court.
He files under Article 32.
Now, can you explain the strategy here? Usually, if you dislike a high court ruling, you file an appeal, an SLP. Why didn't he do that?
That's a really sharp point. An SLP would be asking the Supreme Court to check the High Court's logic. But the High Court's logic wasn't the problem.
Right. If you assume the facts are he never asked for help, then dismissing the case makes perfect sense.
Precisely. So he can't attack the logic. He has to attack the facts themselves. He's arguing the whole process was poisoned by fraud. He's not saying the judge was wrong. He's saying the judge was tricked.
And he's citing a big precedent here, AV Papayas Austria. What's that about?
That case is huge. It basically says fraud vitiates everything. If you get a court order by lying, that order is a nullity. It has no legal standing. It's void from the very beginning.
So he's asking the Supreme Court to just hit delete on those high court orders.
Yes, he's asking for a writ of certiorari.
Another legal term?
It just means he wants the Supreme Court to call up the records from the high court, review them, and then quash them, wipe them out because they were built on a lie, clean the slate.
And he also wants a writ of mandamus.
Which means we command. He wants the Supreme Court to order the state to finally provide the protection he asked for 6 months ago.
But he has to show the injury is ongoing, right, for an Article 32 petition?
Correct. It's about a continuing injury. His argument is that as long as those tainted orders are on the books, the state can use them as an excuse to do nothing, and his life remains in danger every single day.
And the danger is real. This all started with a physical attack.
Exactly. The injury persists because the state has internally acknowledged the threat, but publicly uses these court orders to deny it. That gap is where the danger is.
It's just incredible that this all boils down to one piece of paper versus one sentence from a lawyer. Received versus not approached.
It really exposes a fragility in the system, you know? The courts have to rely on the integrity of the lawyers who appear before them, especially state counsel. We assume they're the honest broker.
But this case asks, what happens when that trust is broken?
And that's why the petition talks about restoring the integrity of the judicial record. It sounds abstract, but it's the most practical thing in the world.
If the record is wrong, the justice is wrong.
It's garbage in, garbage out. If you pollute the factual record, you pollute the judgment. He's just asking the Supreme Court to clean the data, to wipe away the incorrect factual premise, so his case can finally be heard on its merits.
It's a fight just for the right to be heard based on what actually happened.
And remember, he's arguing this himself. As a petitioner in person, he's putting his own credibility on the line against the entire state machinery.
It really is a David versus Goliath story.
With that added layer of the Official Secrets Act threat, that's a really unique element. Using national security laws to potentially suppress a police receipt, well, it sets a very dangerous precedent. It tells citizens, you can follow the rules, but we can make it illegal for you to prove it.
So let's just recap. A witness in a major case is attacked. He goes to the police, gets a receipt. The state tells the high court he never came. The court dismisses his case. The state then uses those dismissals to block him further. And now he's at the Supreme Court saying, look at the receipt, look at the lie, fix the record, and protect me.
That's the entire story. It's a massive stress test for Article 32. Can the Supreme Court reach down and correct a factual lie that happened in a lower court? Can they pierce the representation to see the record?
It makes you think. We all assume that if you have a stamped document, you have proof. You're safe.
But this deep dive shows that proof only matters if the system is willing to look at it.
And that really leaves us with a provocative thought, doesn't it? We live in this age of data, of records. But in a courtroom, a verbal statement from a person in authority can apparently just override a physical document.
Yeah, and if an official stamped police diary entry can be erased from the narrative by a lawyer just saying it didn't happen, then what really constitutes proof for any of us?
A terrifying question. If the official record can be ignored, what ground do we actually stand on?
It's a question the Supreme Court is now going to have to confront.
We'll be watching to see if the record can finally set the record straight. Thanks for taking the deep dive with us.